This is The Law Matters, and we're here to help you understand it just a bit better. Hi, I'm Debbie Morais, your host and moderator. As we tell you in every segment, we've been here for almost now a decade. This program's been dedicated to making legal topics and information more accessible to you. We try to offer clear insights, facts, real-life examples, and some practical advice at times to help you navigate the complexities of the legal system. A solid understanding of the law, at least, puts you in a better position as you try to figure out how to protect your family, yourself, and at times your business. And in our discussions, we have found that you've been able to handle some issues yourself, which is great. More often, however, we find that people do want to seek professional guidance. Our understanding is that it puts you in a better position to communicate with them, to collaborate with them. They'll be better prepared, and so will you when you address them. Our goal always is to help you save time, money, and as always, we want to help you achieve the best possible outcome. We want to again welcome and thank Attorney David Bazar from the Bazar & Associates law firm in East Providence for his legal knowledge, his valuable contributions to all of the issues that we tackle each time we meet. Today, we're going to discuss personal injury cases, a perennial favorite, I guess. Are they ever a do-it-yourself? Probably not. David may find a few that might be something you could handle yourself, but generally not. A few fun facts here. In 2025, there are 39.5 million personal injury cases requiring medical treatment in the U.S. annually, or roughly 126.3 cases per 1,000 people. Interestingly enough, over 95% of those personal injury cases are settled out of court, not tried in court. Car accidents still end up being the most common type of personal injury, and about 10% of all civil case filings. So at this point, we want to review what is it that you need to know. How are cases handled? It's about compensation, surely, but how is that computed? How is that determined? So we know that that's a branch of tort law, and it's about people being compensated for some injuries and negligence. What's it really encompass?
So if we were in law school and we were taking torts and we were dealing with negligent cases, we would look at a breakdown of what negligence is. So negligence starts with a duty. People owe a duty to somebody else. So if we're going to use an auto accident, for example, you have a duty to drive carefully. And then there's a breach of that duty. In this particular hypothetical, the breach of the duty is you hit the car that was stopped in front of you. So you have a duty, you have a breach of the duty, and then you have proximate cause. Was your hitting the car in front of you the proximate cause of the damages that the person's claiming? And so this can be an interesting situation. You could have a case where someone stopped at a car and you hit them, but they suffered no injuries from that whatsoever. So even though you were negligent, your negligence didn't cause an injury to someone else, so there's no claim. On the other hand, you could have someone who was in the car, you hit the car, and not as a result of that, but coincidentally, they had a heart attack and died. Did your negligence cause them to have a heart attack? And if it's not medically associated, or there's other proof that it had nothing to do with it, even though they had damages, it wasn't as a result or the proximate cause of your accident. So the first part of negligence in law school that we learn is whether or not there's a duty, a breach of a duty, proximate cause, and damages. Most people skip all of those things and they say, okay, I was at a red light, I got rear-ended, and my neck hurts. So they shortcutted right to the fact that there are damages. So now, as lawyers, what we look at is not so much of the preamble that I just gave, because we assume that's a given, but were you hurt? What are the extent of your injuries? And is there a deep pocket to recover from? And generally that means, is there insurance?
What if the person happened to have, arthritis in their neck? You don't need to know that if you were defending them. Does the insurance company go after that? I mean, we're jumping over several things right now, but certainly they could have had their neck hurt by the impact of that car. That whiplash is always an issue.
So now that actually plays right into exactly what I said at the beginning, which is, what are the damages? So were they suffering from arthritis already? Was it made worse by the accident, or was it unchanged? So sometimes we find that somebody may have had a prior neck injury. They may have had arthritis, but they had no issue with it whatsoever. Never treated for it, never had a problem with it. It was an underlying condition that they had for years and years and years, but never raised its ugly head until the accident. So now, what most insurance companies would say is, well, they should have recovered from that whiplash within 6 to 8 weeks, but now it's stretched on for years and it's not getting any better. We shouldn't have to pay for all that. Although I think the law would tell them, oh yes you do, because you took somebody who had an underlying condition that was otherwise asymptomatic, not causing them any problem, and you take your victim as you find them. So in law school, we may have called that the eggshell skull theory, which is you tap somebody on the head, it shouldn't do any damage. But if somebody had a really thin piece of skull and you hit them in the head negligently and it caused the skull to fracture, you're responsible for that. Not because you don't get off because that normally wouldn't happen, but you hit them negligently and it happened because of the underlying problem. Same thing with the underlying arthritis. You take your victim as you find them.
That's an interesting thing, which of course is why I imagine most people don't want to do personal injury cases because by themselves, because how you prove to someone as an insurance company that they're going to say, no, you had something else going on and that wasn't the cause. So I can understand why that happens.
It can be very complicated.
So most people talk about the big payouts. What factors influence compensation? I understand that if you have an accident, you're going to the hospital, you have some medical issues right away, you might have a checkup later on that could happen 1 week, 1 month, 1 year. How do you gauge a case? How does that proceed?
Yeah, so damages are usually assessed based on what the injury is, and pain and suffering is the first thing that most people think about that plays into it. So first of all, let's take a hypothetical injury. And typically, if someone's rear-ended in an accident and it's a moderate impact, they may have back and neck pain. And so now, how does that affect your daily life? Does it stop you from being able to work? So if you're injured to the extent that you're a truck driver and you are required to lift boxes, up to 50 pounds, and you can't lift anything above 1 pound or nothing at all, so you can't do your job. So now the impact to your life has been the pain and suffering and the loss of work because of the injury. So the second thing that feeds in after pain and suffering is, are there economic losses, loss of wages, loss of other opportunities, those types of things. And then, of course, the medical bills that you're going to be responsible, that you have to get treatment for to get yourself better so you can get back to work.
When they refer to non-economic damages, is that the amorphous pain and suffering? How do you put money, how do you associate a dollar figure to that? How do you gauge or put a dollar sense on my emotional suffering? We talked about it before as if you're married and you can't really conduct your marital relations as you once had. I don't know what the dollars and cents of that are, but how do you proceed with that?
So non-economic losses, as we were discussing, pain and suffering. So pain and suffering can be the things I described, which are pain and how it affects your daily life. You could have had an injury where your arm was broken, or you had damage to your rotator cuff or something of that nature, and you've gone through the treatment, and now you're never going to get the full use or range of motion of that back. So that's another non-economic loss. You could have scarring. You could have been injured, and as a result of it, there was glass or whatever, and it did scarring to your face. So you have disfigurement from the accident. So that's another thing that needs to be calculated out as to what's the value of that. Go ahead.
How do you know what the value of that is? I think I might need a cosmetic surgeon, okay? It may or may not work, you don't know that. And how much distress and impact does that have for the rest of someone's life? How does that never mind recovery time, just ongoing for the rest of someone's life? How do you
so
put a number on that?
The jury instruction to the jury so they can reach a verdict on that might be, how does it affect the person themselves? So every day the young lady looks in the mirror and sees the jagged scar on her face, which has been repaired as best as it can be, but it's always going to be there. And she sees that and she deals with that and how people look at her. And so the jury's asked to put a value on it. You don't quite sit there and say, well, how would you feel? What would you want? But it's kind of that type of thing is, what is it worth to have to see that every day? That you're kind of asking the jury or the insurance adjuster to say, look at it. And oftentimes you'll hear pushback with, well, that's a guy, not a girl, and that's this and that's that. And you want to go there with some of that? But they do. And it's really, what is it? Because the bottom line is, if I can't settle with you, I'm going to a jury. What is a juror going to feel that that's worth?
Interesting. So you talk about the duty of care and there being a breach, and the issue about compensation. What if that minor breach doesn't seem to warrant all the rest of what went on? So you've had examples, we used to talk about the banana peel, but if somebody drops a container of milk at the grocery store, someone else mops it up, it's still wet there, they cleaned that up. Someone else comes in, there wasn't a sign that said this is wet, watch your step. Someone slips and does a nosedive. There was a duty of care, there was a breach of duty. They did do something to fix it. They didn't get to put that yellow sign up. Someone hurts themselves. Maybe they get a bruise, maybe they get a broken bone. How do you get to determine how much really they should have to pay based on, what that outcome is? That sounds like a very awkward thing for anybody to have to deal with, although I'm sure you deal with it often.
So, first you can start with this. You calculate out what the damages are. So you said it may have been horrific damage, but very slight, and you're calling it slight negligence. Well, either you're negligent or you're not, but there is another issue that should factor in and can factor in. And it happens a lot in slip and fall cases, and that's comparative negligence. And what you're doing there is you're saying, okay, we'll take the grocery store. They did what they did, and they cleaned it up, but they didn't put up a cone. And let's say that they really had no intent to put up the cone, but the wet space was clearly evident, and the person walking should or perhaps did notice it, but kept walking anyway. So now there's some negligence on the grocery store for not putting up the marking, but there could also be negligence on behalf of the person, the plaintiff who was walking and saw a wet spot but kept walking anyway. So the jury can, if we're going to a jury trial to determine this, or the lawyers and the adjuster can, look at it and assess what each responsibility is in causing the final injury. So you could say that the cause of the accident was 50% caused by the failure to put up the appropriate warning, but also 50% caused by the plaintiff continuing to walk. And if that's the case in a comparative negligence state, as opposed to a contributory negligence state, which we can talk about a bit later, the damages are reduced by the amount of the plaintiff's negligence. So in that case, if it's 50-50, the plaintiff would only get half of his or her damages.
So I do want you to talk about contributory, but let me give you another example, because this is another one where gauging who is responsible and to what extent. So you have a lovely home, you have a deck outside your property, it overlooks a lovely lake, you have guests over, you kind of know that there's something wrong with that deck, it should have been bolstered, you really should have taken care of it, you didn't, but it's a lovely night, everybody wants to be out on the deck, it crosses your mind, oh, I hope it's okay, but I'm not sure. If you say to your guests, you know, I haven't had a chance to fix that deck, I'm not really sure it's great for everybody to be out there, and they decide they go out there anyway. Well, they did, lovely sunset over the lake, but it happens. You've heard of the decks falling through, whether they were concert halls and bars or someone's home. So the deck collapses. Some people are injured. Medical issues for everyone who was hurt, of course, but then there was a duty of care, there was a breach. Is there some issue about, but I told you and I warned you, I didn't put the yellow tape on preventing you go through the slider to get out to the deck. How do you handle something like that?
Yeah, so that's a tougher one because you've invited those people out onto the deck. You
had invited them to the party and you said, oh, yes, it is lovely out there, but I'm not sure. I really didn't fix that deck and I meant to.
So you should have closed the deck off if you thought there was an issue.
Is that where it comes down, just that black and white?
Well, in that kind of situation, to me, if you're inviting people over and you're allowing them to go on the deck, you're inviting them to go on the deck. And if you're inviting them to go on the deck, more of the negligence, if not all, has to be on you, because the folks who are on the deck, unless the defect is open and obvious. So if they go on the deck and you say, hey, look, I just want you to notice that the joists or whatever they're called, the beams, they're rotted and this one already fell through, and you still go, maybe you're going to have some comparative or contributory negligence on you. But unless that defect, the failure to repair that you haven't done is open and obvious, just telling them there might be an issue out there, but go ahead. It's
on you. How about if I just say it's on, you shouldn't, I wouldn't.
No, I think you would have, if you said to them, all right, this is a failure, this is a failure, this is a failure, I don't think this can hold your weight. Why are you still allowing them out there? So trying to pass the negligence to them is difficult if you allow them out there.
Good to know. Okay, you were going to talk about
contributory negligence. So some states have a rule that say that if you're more than 50%, or in some other states 51% negligent, you can't recover anything.
Really?
Yes. Rhode Island is comparative negligence, so that even if you're 90% negligent, you can still get 10% of your damages. But some states say, nope, if you're more than 50% or 50% negligent, you're not going to get a thing. There's another defense called assumption of the risk.
Okay.
So what you might argue rather than comparative negligence is, hey, they could see it was rotten. I told them not to go out there, but they went out there anyway, so they assumed the risk. And if you knowingly assume a risk, then that's a bar for recovery too. And the most well-known case in Rhode Island, I believe, was Kennedy versus the Providence or Rhode Island Reds hockey team at the old Rhode Island Auditorium. And so a fellow went to a hockey game and someone shot a puck that came out of the ice and hit him in the head. And he wanted to sue for the damages, but the Supreme Court of Rhode Island said that he assumed the risk because it's well known that hockey pucks can come out and hit someone in the audience. So it was a knowing assumption of the risk, so there was no recovery, if my memory serves right.
I imagine this is why in so many cases there are waivers that they make you sign assuming risk, and if you do this, you do it at your own peril or whatever.
A lot of like zip lines
Yes.
or things of that nature.
Yes.
The question is that a knowing waiver of your rights?
Interesting. But if there was something wrong with the bungee cord or something, then
that's
it's another
negligence.
story.
Yep.
Yeah. So you're going to say contributory?
Yeah, so I covered it.
Okay.
You're good.
Fair enough. So as we're talking about the things that impact on it, there's also something called the statute of limitations. And we didn't go back and even discuss from the beginning, as we usually do, what happens at the beginning of a case. The one thing I know that we always start with, document whatever you can, take a photo, take a picture of whatever happened, get yourself to a hospital. How soon after do we have to determine this is going to be an issue for the insurance company and a legal case and whatever? How does that play out?
Okay, so to go back to the documentation, I actually recently had a case where a client came in and the issue was who was responsible for the accident. Our client was backing out of his driveway and the defendant was backing out of another driveway, but not only backed out of the driveway, but backed over the double yellow line into our client's lane and hit our client. And our client had the foresight to take a picture of the scene where the accident happened with the cars in the place or spot of the accident, showing that the other car crossed the double yellow line and came into their lane. So that was very good documentation right out of the box. So you document it, you get your medical records, you go to the hospital, you come to the lawyer. The lawsuit or the case has to either be settled or filed in a personal injury case in Rhode Island within 3 years of the date of the accident. That's a 3-year statute of limitation.
Is that a typical, or do you have any idea about our neighbors in Connecticut or Massachusetts? Is that
Not
about
100% sure, but I believe Mass is still 3 years. I think Connecticut might be 2.
It's not from the time you discover how bad your injury was. It was from the time of the event.
Yeah, at the time you knew there was negligence.
There was negligence.
So like in a medical malpractice case, for example, there is somewhat of a discovery rule that there was a problem because you may have had an operation on day one, but not known until weeks, months, or years later that they left a sponge or something inside of you when they did the surgery that is now causing an infection and a problem because you were unconscious when you were having the surgeries and you didn't count the sponges. Theoretically, the hospital staff did.
Yes, the onus or the burden.
So that would be a little bit of a discovery rule exception to that.
Okay, so when someone says, David, I think I have an issue here, I think this is a case, how do you determine, what do you have to do to determine whether or not this is really worth pursuing or, just wait and put a nice pack on that and that's the end of it?
So generally speaking, you want to get the medical records and review what the treatment is and see whether or not there's a documented injury that is worth pursuing. So you should know that pretty quickly out of the gate. A lot of times after we get the first reports or something, we may tell a client, you may want to handle this on your own. It's not worth engaging us to do that.
Yes, and that might be if there's just they needed stitches, but we're not talking about anything beyond that. Would that be something that someone could
they're
possibly...
entitled to some money for that because there's going to be scarring from the stitches and some disfigurement. But if somebody went to the hospital because they had some injury from the accident and then never followed up for treatment or wanted to go much later, the delay can be an issue. I mean, if it's a week or even some months because it takes time to get in sometimes to see a doctor and whatever, but you're doing things for it, that's okay. But if you came to me and said, I had an accident 1.5 years ago and I'm just not any better, really, I'm not going to be that interested in pursuing that case.
So if you decide that there is a case that has enough merit that you should pursue it, what happens next? Do you have to go investigate the scene of the crime if there's something that's needing to be seen? How do you handle the case?
So I've had cases where they've disputed liability. So I've gone out and I took a look and my client says that it was 2 lanes that became 1 and then this person came from a side street and did this. And, so the actual setup or logistics of the street may be important. And so we'll have someone go out perhaps and film how the cars travel and that type of thing to show whether or not what our client has told the police and the police report is accurate. A lot of times it's pretty straightforward. There was a red light You were stopped at the red light, you got rear-ended. Sometimes there's a red light and both sides are claiming the other went through the red light. So we'll do some investigation there. One time I looked around the site and saw that there was a place of business that had a camera. So I asked for the video from their camera, which clearly showed my client had a green light and the other person went through the red light.
So those things matter. So if you have that kind of documentation and certainty, does that make much easier time of getting to settle versus going through full boat trials?
It can absolutely help. I had another case where my client was driving down 95 and the defendant, the person who hit her, claimed that he cut her off, even though he rear-ended her. And so the insurance company was giving me a little pushback. What they didn't know and what I sent them was my client had a dash cam. And it showed her driving down the highway. It showed her passing an on-ramp. It showed her continuing to drive in her lane. And then several minutes really later, while she's in her lane, the defendant rear-ended her. And so that quickly turned it from a disputed case into a settled case.
How often does it happen that you are, it looks like you're going to go to trial, then you have to prepare for it, and then just before you go to trial, or maybe a half an hour into it or some short stint into it, they decide, the insurance company decides to settle? Is that a frequent
situation? The vast
situation?
majority of cases will settle before a trial.
Before you get to a trial. And that certainly saves you time and saves everyone money.
Perhaps.
Perhaps. Interestingly enough, in 2025, I was just looking at some of the whoppers, for lack of a better. An attorney, there's one in Texas, $831 million verdict, one of the dram shop cases, which is someone's drinking and it was, well, someone ends up in an accident at a motorcycle flips over and sprays the contents of whatever it had in its back, in its side. Someone ends up having an accident as a result of that, and the suit ends up being that someone was driving impaired, and who gets sued? Not only the restaurant that served a minor, served to make them 3 times over the legal limit, and not only served the restaurant, but separately the owner. Deep pockets, we've talked about that before.
It depends on who the license holder was in that particular case, so that may have been why.
The owner versus just the restaurant itself.
Right, because the restaurant might have been the owner of the liquor license, the person individually was, but usually there's insurance to cover that. The outrageous verdicts are very unusual and get overturned or reduced. So $831 million for a personal injury case is not generally going to stand unless it was a class action suit of some type. That's possible. The dram shop cases, the one you cited, had a case that would have strict liability in the sense that the restaurant or owner or whoever served a minor, that's strict liability. You're supposed to check the thing. And overserved, which is another issue.
Good.
So those can be very interesting cases.
Thank you for setting that record straight. That was really an awful large sum.
Yep.
We thank you for tuning in to The Law Matters. We hope you found this interesting and helpful. Continue to stay tuned as we say The Law Matters to you. Thank you.